I have this restraining order from 12 years ago and the judge made it permanent. Is that really like lifetime or permanent? I'm Adam Rossen with the Rossen Law Firm, and in today's video, we're going to keep diving deep in our series on restraining orders, commonly called injunctions, in the state of Florida. And a question that we get quite often is, well, how do I go in and modify a restraining order? Or, I have this restraining order from 12 years ago and the judge made it permanent. And, is that really like lifetime or permanent? Like, can I do something about it, right? So can you modify or change or, reduce a restraining order against you? We get this question all the time. So the answer is yes. Of course, it depends. So what does it depend on? You need to have a material change in the circumstances. So it can't just be you walking into court or filing a motion or a lawyer doing it saying, well, judge, we know 12 years ago you or another judge made this permanent, but it's been 12 years and there's no need for this anymore. Because the judge is going to go, well, I think it's working. We made it permanent. There's been nothing for 12 years. So it seems like it's working, so I should probably keep it, right? That's the kind of thought process in the law and by the judge, okay? So there has to be a material change in circumstance. So just talking about time alone is not going to solve anything when we're talking about modifying a restraining order. So what is going to solve it? It's a material change in the circumstances. So let's talk about that. So one example would be if the parties move, right? So if the petitioner now lives in California and the respondent now lives in Georgia and they don't know where they live, they just know they're in other states. There's been obviously no contact, but there's no way for them to bump into one another. There's no way for whatever the underlying issues were to continue. And the fact that so long of time has passed, right? Not the sole factor, but that could be part of it. Well, that seems like there's a material change in circumstances. If, 12 years ago, they both lived in Broward County, South Florida, in Fort Lauderdale, they were dating, and now it's been 12 years, one's in California, one's in Georgia, there's no need for this anymore. They've both moved on with their lives, right? So that's an example. Another one would be, well, if the petitioner dies. And people would say, well, Adam, if the petitioner dies, why does it even matter, right? Well, and here's why it matters. Obviously, the chances of violating by having contact are none because the person's dead, the petitioner's dead. But if it doesn't mean that the case is automatically gone against the respondent, the person that has the restraining order. And what that means is when you have a restraining order against you, they take away your Second Amendment rights to own and possess a firearm. So you can have a permanent restraining order. The person can pass away, die, and that still means that you're not allowed to own or possess a firearm. Now, for some people, it's not a problem at all. They don't care. But for others, their Second Amendment rights are essential. They are constitutional rights, and they want to be able to legally own and possess firearms. So that is a big deal for some people. So in a situation like that, where the petitioner dies and there is a permanent restraining order or a long-term, maybe a 5-year, a 10-year, restraining order, you definitely want to go in there and ask the judge, file a petition, of course. You can't just walk into court and ask the judge, right? You got to file the appropriate motions, but file those motions and say, Judge, this is no longer, needed. There's a material change in the circumstance. I want this gone. Okay. So that's another big common example that we see. And the last example that we see is, well, maybe if there's a reconciliation among the parties. Now, yes, that is a material change in the circumstances, but I'm going to consider that a little different because this is an example where the parties agree. So if the parties both agree that this is no longer needed, then that's even the easiest one. We can file an agreed petition with agreed orders, and some judges will sign it right away. Some judges will require an affidavit. Some judges will still require a court hearing just to see the person and hear it, themselves and get it officially on the court record and get a transcript of it outside of just the court filings. But, yes, it's a material change in the circumstances. Basically, the petitioner saying, I'm no longer in fear, right? But that's just still a much easier way, because the first example I gave is more of it could still be contested if the petitioner is still saying, well, no, I still want to go through this, or whatever. So that's another example. It's always better if the parties can agree. If the parties can agree, then it's less to litigate over. It's less to fight over. It's less to put the chances, the uncertainty and the potential chances of getting it denied with a judge, right? Just to walk in and say, Judge, we're all in agreement here. We just need you to stamp this off. So that's another part of this that I think is important for people to know. Like I said, we get this question quite often about, how do we go ahead and modify or change this? So those are really the basics as far as what you need. Okay, if you have any questions about this, if you find yourself in a situation where, you've had a restraining order for a long time and it's not needed anymore for a variety of reasons. And look, we know that these come up on background checks as well and can hurt people for future employment or for where they live. You go through a background check for housing. A lot of people are going to go, you got a restraining order. You're a violent person. We don't want that riffraff. No, not going to rent to you. So if you're ever in these situations and you need to clear this stuff up, give us a call. Let us know here at the Rossen Law Firm. We handle these all the time. Tons of injunctions and restraining orders in South Florida. You can call us 754-206-6200.